Okay, I think we'll get going now. So thank you everybody for joining us today and taking the time to attend our webinar. As you know, we're going to be speaking today about the employer's duty to accommodate under human rights law. So just a couple of housekeeping items. The main one being that if you have any questions, please enter those in the Q&A section, and Randy and I will get to those at the end. We've saved some time after the presentation to answer your questions at the end. So we will have time to get to those then, and that will work perfectly. If you are having any technical issues, you can reach out via the chat, or you can certainly email Piper at pbrown@getzcollins.com. And she can help you hopefully get reconnected if you are having any issues. So your presenters today are going to be, there's two of us. The first one will be me actually, but I'm going to tell you a little bit about Randy first. So Randy Collins is our managing partner here at Getz Collins Associates. She's been practicing in a number of areas of law for quite some time, and she does focus quite a bit on employment law and has a lot of experience dealing with human rights in the workplace. So she's going to be an excellent speaker today. And then I am Kristen Iwani. I am a senior associate at Getz Collins Associates, and I am also the practice lead for the General Litigation and Employment Group. I've been practicing employment law for a number of years, and I particularly enjoy the area of workplace human rights, so I'm really happy to be here to be able to speak with you today. So just a bit of an agenda so everybody knows what the plan is for the webinar today. We're going to be speaking about 5 different areas really of the duty to accommodate, or different pieces. The first one being, what is the duty to accommodate? It's a word that gets tossed around a lot, but important to sort of understand exactly what that is and where it comes from. Second, we'll be looking at the accommodation process itself and how that works and what the different obligations of the parties are in that process. We'll then move on to look at what constitutes reasonable accommodation, or what might in certain circumstances. We'll talk about why it's situation specific. We'll then move on to talk about the exceptions to the duty to accommodate, and finally sum up with the consequences of failing to accommodate. And then we'll move into our question section where you can ask any questions, but do again, feel free to enter those in the Q&A at any time, and we will get to them then at the end. So looking at where this sort of all comes from. So there is human rights legislation across the country. In Alberta, most employers are provincially regulated. That means that they are going to fall under the Alberta Human Rights Act. However, you may be at a federally regulated employer if you are in telecommunications, aviation, pipelines, banking, those kinds of things that fall within federal jurisdiction. There is a separate act that applies to you, and that would be the Canadian Human Rights Act. The provisions in both are quite similar, so I'm not going to get into what the separate provisions are in each, but just so you know, I will mention if there are any differences that you may want to be aware of in case you are in a federally regulated workplace. So essentially, human rights are governed by the applicable piece of legislation. Both of those pieces of legislation, whether we're talking about the Alberta one or the Canadian one, provide a framework to protect against discrimination and promote equality in various areas, one of those being in employment practices, which is what we're talking about today. And we'll get a little more into that as we move forward. So under that legislation, employers have a duty to provide reasonable accommodation in order to address discrimination and promote that equality in the workplace. That means that an employer has to make reasonable efforts up to the point of undue hardship, and we'll get into more detail on that later, to change rules, standards, policies, procedures, workplace culture, and potentially physical environments in order to eliminate or reduce the negative impact faced by an employee because of a protected ground under the applicable legislation. So one of the first questions we then ask after that is, well, when does that duty apply in the context of a workplace and employment? And the answer really is that it applies at all times where a need for accommodation is identified. So that means it's going to apply in advertising a position. There could be a duty to accommodate if someone reaches out looking for accommodation in terms of that. It can arise in terms of interviewing candidates if there's an accommodation request made either in particular for the interview itself, or if the employer is advised, or potential employer is advised that that individual requires some accommodation in their employment on a go-forward basis, and then also throughout the full duration of employment, right up to and including the end of that employment when that happens. So what does that duty to accommodate apply to? Because it doesn't apply universally. Well, the legislation has specific protected grounds, and the duty to accommodate is only going to arise in relation to something that is falls under that protected ground. So in Alberta, we have 15 different protected grounds. There are a similar number under the Canadian Human Rights Act, although there are a few differences. So it would be important if you're at a federally regulated workplace to check what the protected grounds are under the legislation. It's quite easy to find, and the Canadian Human Rights Commission has good information on their website in that regard. Generally, the duty to accommodate is going to arise most commonly in terms of the first four. So, and those are the ones we're going to talk about today. So that will be physical disability, mental disability, religious beliefs, and family status. And we will get into a little bit of detail on each of those as we go through the webinar today. So looking at the accommodation process, if we move into that now, we've talked about the duty to accommodate and what it is and where it comes from, but the accommodation process itself. So that process is really intended to be collaborative. That means with all of the parties working together to try to come up with accommodations that will suit whatever the situation is. So this means that responsibilities fall both on the employee and the employer in the process. If you are in a unionized environment, then there will also be responsibilities that fall on the union, because in order for some accommodations to be implemented, the union needs to be involved because it might involve something that is not otherwise provided for under the collective agreement. And so there's a need for the union to participate in this process as well. We're not going to get into that as much today, but I did want to mention it in case you are in a unionized environment, that is something to be aware of. If we then look at, well, if everybody has obligations, what are they? So in terms of the employer, the employee, the obligations start with the requirement that if they need an accommodation, they need to initiate that process. So that means they need to let the employer know that they're looking for some kind of accommodation. Now, there is an exception to this where the duty could arise if there is a duty to inquire under human rights legislation, which means that if there's something going on, the employer has noticed certain things happening and has a reasonable basis to think there might be something deeper going on that would be connected to a protected ground. This is often a suspicion of potentially a medical issue that might be a disability, leading to performance issues that are quite out of character or something along those lines. Then the duty to inquire might be triggered, and then the employer might need to ask the employee if there's something going on and if they have any restrictions that need to be considered, and then the duty to accommodate would come into play there. But that's going to be more rare, and we could spend a lot of time talking, I think, about the duty to inquire itself, because there's no clear, definitive line as to when that kicks in, but it could come up. Another obligation that the employee is going to have is to provide all reasonably necessary evidence and documentation to support their request for accommodation. So that's going to depend on the specific ground that they are looking for accommodation of. If it's a mental or physical disability, generally that's going to involve providing reasonable amount of medical information to indicate what their restrictions are, so what needs to be accommodated in the workplace or for their work in order for them to be able to do it. If it's a religious belief or a family status matter, then the amount of information or documentation you might be needing is going to be different. And it's important in that to remember that you want to be considerate of how much information you're asking for and only be asking for what is reasonable in order to try to be able to accommodate the employee. The employee's other obligation will be to cooperate with the employer in identifying reasonable accommodation measures. That does not mean that the employee has to come up with kind of all the ideas or be the one who originates an idea for accommodation, but it does mean they need to participate in that process. So it might mean getting together with the employer to discuss the potential options the employer sees and maybe bringing forward their own thoughts on what might work for accommodation. They also have an obligation to agree to reasonable accommodation measures. What that really means is the employee can't hold out for what they consider to be a perfect accommodation. So if they have in mind some specific way they think they should be accommodated, but that there is some other reasonable accommodation that's put forward by the employer that isn't that perfect accommodation, the employee would then have an obligation to accept that reasonable accommodation and not hold out for that perfect accommodation. And then the employee will also have an obligation, a continuing one throughout the process, to let the employer know if there are changes to whatever their restrictions are or to their situation that might require a change to the accommodation, or that actually mean the accommodation can cease, so it no longer is required. So that is something employees are going to need to do. In terms of the employer's obligations, the first thing you're going to do if an employee comes to you looking for some kind of accommodation is to determine if it falls under a protected ground under the applicable legislation. If it doesn't fall under a protected ground, then that is something that the employer can consider solely from a business perspective. They don't need to be concerned with the duty to accommodate. It's just something that will be considered based on practicality, the business realities, and whether it's something the business is interested in trying to offer or look at, or if it's not, then simply advising the employee that they're not going to be able to accommodate that request. As I mentioned, when talking about the employee's obligation to provide reasonable information, it's also then on the employer, once they determine there is a protected ground at play, to request any additional information and documentation that might be appropriate. I think in many circumstances, this is going to happen where the employee might just come and say, oh, I have to pick up my kid at 4 every day. I can't accommodate this new schedule or something like that. You may need a little more information from that employee. It particularly comes up in the context of a disability, whether physical or mental, because the employer is going to need more details about what the restrictions that employee has are. In requesting that information and documentation, it's important to consider that you only want to request what is reasonably required in order for you as an employer to make an assessment of what accommodations might be appropriate if the restrictions can be accommodated in the workplace, and what the available options are. And it's important to respect the dignity and privacy of the employee in that process. Now, you may have a third party involved that's actually dealing with medical information if we're talking about a disability. And then, you may just be advised kind of outside of that what the restrictions are and those kinds of things. But if you as the employer are the one dealing directly with the employee, that's an important piece to keep in mind. Most third party insurance providers are well aware of the need to only request what's reasonable. And so generally they're gonna comply with that, and you're not gonna know exactly what they've asked for, but you'll know what you get. So employers are also required to collaborate with the employee and the union, if there is a union involved, to identify what might constitute reasonable accommodation measures in the situation, and also to then agree to some form of reasonable accommodation measure or measures, depending on what's going on exactly. The employer also then needs to take reasonable steps to accommodate that employee to the point of undue hardship. I mentioned that one once before, and I'll say it one more time because Randy is going to get a little bit more into that undue hardship piece. It is quite a high bar, and she'll give you a little bit more information about that as we move along in the presentation. As an employer, you're also obligated to follow up to make sure the accommodation measures are working. That means, once they're put into place, you don't just sort of leave it and walk away and go, okay, the accommodation's done. It's important to follow up with the employee, check in, make sure it's working, make sure nothing's changed from the employee side of things. That might mean the accommodation needs to change. It's sort of an ongoing process as time goes on. So it's important to kind of keep tabs on that. And then, regularly reviewing and then modifying accommodations if the circumstances change. So particularly if the employee comes to the employer and advises something's changed, either their restrictions have changed, or maybe they no longer require the accommodation, at which point that can be brought to an end. So important to be doing that on a regular basis as well. And the union, if they're involved, has an obligation to participate in the process to help find reasonable accommodations, and then maybe to make some accommodations on their side if they need to make some exceptions to certain things in certain circumstances. So they're going to have some obligations as well. So in terms of best practices in implementing accommodation measures, first you want to engage in open collaboration, as I mentioned, to have so that you have a well-rounded assessment of the situation. The more that collaboration that you have with the employee and the union, if they're involved, the better options that are probably going to be brought forward for potential accommodations in the situation. And then second, you want to be flexible and creative when you're identifying possible accommodation measures. So not being tied to maybe only what's been done in the past in other similar situations, but considering other options that might be a little bit more creative, a little bit more outside the box. It may be that they won't work, but maybe it's something you could try for a little bit of a period of time. And then if it's not working, adjustments can be made. As I mentioned, it is sort of an ongoing process. It's not a static process where it's just going to come to an end, and nothing else will have to be done necessarily. Third, and this is going to sound very much like it's coming from a lawyer, which it is, and I'm going to tell you to document as much of the process as possible. There's a few reasons for that. If things don't go well and the employee ends up filing a human rights complaint, it's probably going to be at least a couple of years before you're going to get to a tribunal hearing, if there is one. And most people's memories are not going to be that great. So you're not going to remember maybe all the possible options that were considered and why options didn't work. So you'll have that record if you're keeping track, but it also having that documentary evidence will be a bonus at the tribunal stage. It's important to document all of the options, I would say, that were considered, and for any that were determined not to work, why they wouldn't work. And maybe, that may be that it would cause undue hardship, or there may be some other issues that went on, or why it wasn't reasonable in the circumstances. That's going to be very helpful to you down the road if there is any kind of a hearing or a dispute about whether the accommodations provided were reasonable. So really keeping good track of that information. That might include too, if you have to consider other positions because the employee can no longer do their position, perhaps, given whatever the accommodation is they're seeking. Keeping track of what other positions were considered and maybe why, if they weren't appropriate, why they weren't appropriate, or if they were offered to the employee and the employee refused, because again, they have an obligation to accept reasonable accommodation. So that will also be helpful to you. And then finally, you want to review those accommodations fairly frequently and adjust the measures as appropriate. That works from both sides. I mean, there may be an accommodation provided that's not working for you as an employer, and you need to make some adjustments that still meet the employee's needs. So that's something to keep in mind as well. So moving into what constitutes reasonable accommodation is going to vary in every circumstance. And that's because it's been established that reasonable accommodation is a very context-specific thing. It has to be assessed on a case-by-case basis. That means you can't say, for every person who has a physical disability, we will accommodate them this way and just apply that as a blanket kind of policy. You really do have to look at that individual circumstances and assess what's going to be a reasonable accommodation for that person at that time in your business. You also want to make sure the accommodation is rationally connected to the protected ground. So it's not something where you're moving them into a position that makes absolutely no sense, and is not connected to whatever their restrictions are just because maybe that position's empty or something else. There needs to be that rational connection there. And I think all employers I've ever worked with always have that, but it's worth mentioning. And again, the employer has to accommodate up to that point of undue hardship. So if we're looking at accommodation for religious beliefs, in looking at what constitutes reasonable accommodation, religious beliefs is not actually something that's expressly defined in the legislation. So there is no specific definition of what will constitute a religious belief. But the case law over time has basically developed one that is essentially a definition, but it's quite broad. So you're going to find that there are many things that could potentially fall under a religious belief. So it is considered to be a freely and deeply held personal conviction or belief that is connected to that individual's spiritual faith and integrally linked to their self-definition and spiritual fulfillment. The practices of which allow them to foster a connection with the divine or with the subject or object of that spiritual faith, whatever that subject or object might be. So it is quite a broad definition. And so it is something you would need to keep in mind, even if an employee comes forward with a request that might sound a bit odd and not within what you understand to be typical religious beliefs that might require accommodation. It's still something then you'd have to get a little bit more information about as an employer to really understand that. In terms of what might constitute appropriate accommodation measures or reasonable accommodation measures for religious beliefs, that's going to vary depending on exactly what the employee is looking for. But some examples could be offering an exemption to a dress code if a dress code would prevent someone from wearing something that is a part of their religion. So if it's something they wear on their head, a piece of jewelry, something else that is part of their attire that is sort of required by their religious beliefs, then you may need to make a modification or exception to the dress code for that person. Another thing that might come up is if an individual requests time off for a religious holiday, you may need to be willing to give them a leave of absence or that time off to observe that religious holiday if it is part of their religious beliefs. Another thing that has come up in decisions is modifying a work schedule to accommodate an employee who is not permitted to work on a specific day of the week or time of day based on their religious beliefs. And one of the cases we'll chat about today does sort of deal with that. And then at a time such as now where individuals of the Muslim faith are fasting for Ramadan, there might be a need to accommodate that employee either by modifying their duties or perhaps their schedule if they're coming to you looking for that kind of an accommodation in order to be able to observe that fasting under their religious beliefs. There are a lot of other examples. Those are just a few of them that could be reasonable accommodations in specific circumstances. So if we look at a real world example or a case law example of accommodation of religious beliefs and what might be required, we can look at one of the leading decisions in human rights law actually is the Supreme Court of Canada's decision in Central Okanagan School District and Renault. In this case, the individual's assigned schedule included a requirement to work Friday nights. Now, the individual's religious beliefs actually prevented him from working during his Sabbath, which was from sundown on Friday to sundown on Saturday. So the employee was seeking accommodation on that basis, was saying he couldn't work Friday evenings. And, my understanding from the facts of the case is there was an alternate work schedule that was considered, but only to a certain extent because there was a union involved. And under the collective agreement, the schedules were sort of set. So they didn't want to give any kind of an exception for that to allow the individual to work an altered schedule that would have seen him work from Sunday to Thursday instead of having to work on that Friday. So because of that, ultimately that shift didn't get put into place. The individual continued to refuse to work on Friday nights in accordance with his religious beliefs and was ultimately terminated as a result of not working on Fridays. When this got up to the Supreme Court of Canada, it went through the Human Rights Tribunal first and made its way through levels of appeal up to the Supreme Court of Canada. The Supreme Court of Canada ruled that the employer had not reasonably accommodated the individual's religious beliefs. They actually found the union had not as well, because they were involved in it, and said there was nothing that demonstrated that the Sunday to Thursday shift would actually have caused undue hardship to the employer or the union for that employee to be given kind of that modified shift schedule. So that violation was then found. They did order that that employee be reinstated to their job, awarded an amount for lost wages and also for general damages for emotional damage, as well as awarding some additional legal costs. Now, the legal costs would pertain to the fact that this went to the Supreme Court of Canada. Generally, if you're dealing at the Human Rights Tribunal level, there are not often awards of costs made. It's sort of a unique circumstance where there's improper behavior to a certain level during the actual human rights process that might lead to a costs award. Otherwise, they're fairly rare, I'm going to say. So just to keep that in mind. So the consequences can be pretty significant, especially because lost wages can be awarded from the time of the discrimination up to the date of the hearing, less any mitigation earnings, but that's something to keep in mind. And then the last piece that I'm going to speak with you about under what constitutes reasonable accommodation is accommodating a physical disability. So a physical disability under the legislation is any degree of disability which is caused by bodily injury, birth defect, or illness. So there are many examples out there: cancer, epilepsy, autism, hysterectomy, colorblindness, all those kinds of things might fall under there. And it also includes alcoholism or individuals who have substance use issues. So those are all things that might fall under a disability. There are some things that won't meet that test. So things that are sort of transient in nature, like a cold or a flu, isn't necessarily going to constitute a disability for human rights law purposes. So there are a myriad of options for accommodations of physical disabilities, depending on what exactly those restrictions that employee has because of that disability are. But it could include things like purchasing or modifying tools, equipment, or providing aids to physically assist with different things. It might include altering premises to make them accessible, offering time off for the individual to recuperate or attend rehabilitation, or go through treatment, depending on exactly what their disability is. It might also involve modifying job duties or job schedules, or potentially using temporary employees for a period of time, either to assist the employee in their work or to cover for the employee if that employee needs to be off as a result of their disability. So we look at a case law example for accommodating the duty to accommodate a physical disability. There's one decision out of Alberta, the Alberta Human Rights Tribunal in Horvath and Rocky View School Division. So the employee was a school caretaker, and she injured her shoulder while she was performing her duties. So she did have WCB for a period of time. That doesn't really play into what ultimately ends up being the decision here, but just I'm sure everybody will be thinking about that. Her physician eventually advised that she could return to work on a modified basis, so she had to be given light or sedentary work. It was expected initially that that would be temporary, but eventually down the road that did become a permanent requirement for her, even though initially they thought she would fully recover eventually. The employer actually didn't offer her any modified work or allow her to assume a different role. So they didn't actually look at other options. They limited their search for other positions only to janitorial positions that would meet her restrictions. And that was problematic when they got to the Human Rights Tribunal. So ultimately, they did terminate her employment because they said she couldn't be accommodated. The tribunal ended up finding there was a failure to accommodate on the part of the employer because they didn't offer alternative work situations. She actually applied for a number of positions once she was well enough to return to work on those light and sedentary duties. She applied for some, I believe, administrative assistant positions, which she actually did have some qualifications for, but it wasn't what she was working in when she was injured. She was in a janitorial position. But because the employer refused to consider anything outside of janitorial positions, the tribunal said that was a failure to reasonably accommodate because they couldn't establish undue hardship on that point. In that case, the employee was awarded lost wages for a period of 2 years. So that would have been, even at the janitorial level of compensation would have been a pretty significant number. And then also was awarded an additional $15,000 for general damages as a result of the discrimination. And then all of that was subject to interest based on legislation. So a pretty significant award, pretty clear in that case, the employer had not reasonably accommodated, so they couldn't limit their search just to those janitorial positions. And with that, I'm going to turn it over to Randy and let her jump in and start speaking with you about accommodation for mental disabilities.
All right, thank you. Okay, so we're going to go into the next portion of this, which is moving on to some of the less known or less seen, and it's an area that is really emerging as needing more investigation, more focus, I would say, from employers on this standpoint. So when we're looking at accommodation for mental disability, this is in regard to a wide array of different things, which are mental disorders, developmental disorders, or any kind of a learning disorder. And it's regardless of the cause or the duration. So it may be a short-term concern or it may be a long-term concern that may require some accommodation. So things like dyslexia, depression, schizophrenia, obsessive compulsive disorder, ADHD, and anxiety disorders. And that list is not comprehensive. That's just a few of the different things that we do see that may require some accommodation. And so similar to any kind of a physical disability, there are things that you can do as an employer to try to accommodate that. So much like the physical disability, you can request and require some medical documentation to know exactly what the restrictions may be. And some accommodations could be things like purchasing aids to assist with job duties or modifying a job duty itself. Also, it could be allowing for some time off if that might be the necessary option. So some of the aids that could assist, sometimes it could be as simple as the lights are too bright and it's impacting somebody's ability to focus or something of that nature, needing to be in more of a quiet area, or it can range to actually having to modify the workspace as well and allow that time for treatment. So in this example, this Cooper case against this numbered company 133668899 LTD. In this case, the employee was advised by their physician that they needed a temporary leave to deal with some concerns regarding depression and some concerns regarding some stress. And so once the employee advised that she needed just a temporary leave, but that she would be returning, the duty to accommodate wasn't satisfied, and the employer failed to even consider the request or potential accommodation measures. And so in this situation, the employee was awarded some lost wages and $15,000 in additional damages. And so when we see certain situations where employers have a short-term concern, we do see a lot of a higher degree of accommodation and reasonableness needing to be provided, especially if the documentation, as in this case, where a physician has specifically stated it just needs to be a short-term accommodation. Moving on to family status. So family status isn't really well known or understood as to what that actually means. And so what this status is any relation to another person by blood, by marriage, or by adoption. So commonly, we do see situations where it comes to childcare or caregiver obligations. And one of the areas that is really unknown to the general population is the caregiver aspect of this, especially in terms of individuals assisting people that are terminally ill or needing to try to accommodate care for somebody that may have a significant illness. And so it does not protect activities, though, that arise from personal choices. So that does not speak to things that are sporting events, extracurricular activities, specific schools even may not be included. So if there is a school that would be an option, that is the regular school that they have gone to for a very long period of time, but they want to move to a different school based on choice, but it isn't based on any needs of a child, it could fall outside of the reasonable obligations in terms of what is needed for that child care. So when we're looking at some reasonable accommodations, this is when we look at things like flexible shift starts, end times, allowing for pickup, drop off. We've all been likely in a situation where from time to time, somebody may need to leave work early, their child is sick. Those are usually easy accommodations in a lot of circumstances, very difficult in some positions. Obviously, if somebody is client facing, customer facing, it becomes a lot more difficult. But when we're really looking at a lot of these human rights cases, it could be more of a longer term solution in the event that the child's schedule has changed every year. It may come into a different schedule, and just allowing for some flexibility in the event that that is possibility based on their position and their role. Also, leaves of absences or modified working hours to care for critically ill or disabled family members. And these are really important aspects because not only is this contained in the human rights side of it, it's also contained in the employment standards side. So not even just a protected ground. There are some leaves that are protected just in your general employment standards context. But in terms of the human rights side, if somebody is dealing with a critically ill or disabled family member, a leave may be required, or even modified working hours. It may require somebody to work from home for a period of time. Obviously, those accommodations, and we'll look at the extent to which there's limits on those as we look into the undue hardship side. So a real world example is the Clark and Bow Valley College. And on this one, it's a mat leave where the employee was on a maternity leave, but her child was born about 7 weeks early. So that led to some confusion, and this arises quite often when an employee may take even a short medical leave before maternity leave, or if their child is born early, there can be some confusion as to when that employee is set to return to work. And that happened in this case. So the employee was intended to return to work in January, and they did not have any accommodations for their childcare and were only able to come back in February. And so the employee had communicated this, that there was no childcare for that month, and she was actually terminated. So this isn't just a situation where they couldn't find a reasonable solution and there was just in that some type of discrimination. They actually moved to terminate her employment, which would obviously not be advisable in this situation, given that it is a short period of time. And in this situation, the employer hadn't looked at reasonable accommodations or reasonable alternatives of what they could do in that meantime and to try to bridge that gap. And so by them not looking at that further, and then by actually terminating the employment, they were deemed to accommodate it. And they were awarded, they were made to pay some lost wages and $15,000 for injury of dignity and some interest on this one. So it's always important to note that when there are discrepancies, misunderstandings, it is really important, even if it is, you are correct in that she was supposed to come back in January, given that it is based on childcare that she's unable to do so, that triggers the obligation for some accommodations. All right, so now we have the exceptions, and I'm sure most of you guys are thinking, Okay, so it sounds like we always have to accommodate. And when does this end? Where does the limit fall on this? And there are limits, and it's really depending on the circumstance. And like Kristen said, it is case by case. So in terms of when that duty ends, it's up to the point of what we call undue hardship, or if it's a bona fide occupational requirement. So I'll go through what both of those mean. So undue hardship, that can't be trivial. Yes, it is going to be tough for any business if you have to accommodate by changing schedules, moving people around. Those things can be very difficult, but it has to have an impact. So is it a significant financial cost? So for example, are you a small business and putting a ramp into the business for a physical disability? Is that outside of the realm of what the business itself can afford? You know, a multinational, huge company, they would say, I don't think that's going to be unduly hard. Whereas a small company, it may have that different impact. So they actually look at the financial cost in comparison to the actual size of the operations as well. Problems with morale, and this is one that we see quite often. When there are accommodations, especially to work schedule, working from home, for certain individuals, it can impact morale. So it can't be just, I don't think other employees are going to like this. It has to be a very significant impact to morale, such as, you know, that other employees aren't granted their regular shifts, short shifted, that there's excessive overtime or obligations on other individuals, which not only will impact morale, but cause some other potential employment concerns as well. And then as well, the interchangeability of the workforce and the facilities. So in the event that somebody is working up front, so say they're working at a grocery store up front, are they able to manage the workforce or facilities? Can they make some changeability? Are there changes that can be made? There can be changes, such as small changes, like I said, the putting a mat underneath somebody's foot to alleviate the back pain that they have from a physical disability, or they could be able to interchange into an office setting if they're in a different type of position. So if they're normally standing, can we be sitting? If they're normally sitting, can we be standing? Can we put them in a different location? And also, how can we actually adjust a facility? So a warehouse may have different concerns than an office space, where you may be able to make a little bit more of those amendments. And lastly, and very importantly, is safety issues. So as Kristen went through, things such as religious exemptions, although there is a protection to maybe be able to wear something on someone's head, if that poses a significant safety issue, there may be no ability to accommodate because you cannot violate occupational health and safety rules. So you're in a very delicate position. So the accommodations cannot arise to some kind of a safety issue. And then as well, that arises a lot of times when it comes to things like physical labor, whether or not allowing that accommodation could result in a safety issue for others or for that employee themselves. The next aspect and the exception to this is the bona fide occupational requirement. So what a bona fide occupational requirement is where it's a necessary requirement for a job. And as Kristen pointed out, in the one physical disability, that doesn't mean you can't accommodate somebody by finding an alternative position for them. So in the caretaker situation, could they have looked at things like an administrative position? Because obviously injury is directly associated with the caretaker position. So yes, although it may be a necessary requirement, you then would look at something that would be an alternative. If that alternative does not exist, then at that point, it may be an occupational requirement. So for example, if somebody's job is to drive a truck, but they have a physician's note saying that they can't sit for extended periods of time, that is directly correlated to what they need to do day in and day out. The employer can look at some other positions with the company to see if they could accommodate that physical in this circumstance, a disability. And if that doesn't exist, then you could rely on the fact that it is a bona fide occupational requirement to be driving the truck and there is no reasonable alternative. Okay, but there is still that reasonable accommodation to try to find alternative solutions. But in the event nothing else exists, nothing reasonable without that undue hardship, and it is tied to their job, unfortunately, at that point, you'll have to make some decisions as to whether or not you can accommodate. So when we're trying to establish that bona fide occupational requirement, the first thing is it connected? Does the actual injury, does the disability, does the protected ground specifically relate to the functions of the job? And if the answer is yes, there could be that bona fide occupational requirement. Next is the standard was established in good faith. So it's necessary to fulfill a legitimate work-related objective. And we do find that there is some back and forth, especially with individuals requesting work from home or accommodated work schedules based on a disability, as to whether or not that requirement is actually necessary to fulfill a job. An employer's desire for people to be in office does not equate to a bona fide occupational requirement. It has to actually be related to the fact that, no, unfortunately, the person that is the cashier at the grocery store can't fulfill that position at home. It has to actually have a legitimate work-related objective. And third, the standard is reasonably necessary to accomplish the work-related objective. So it must show that the accommodation has occurred to the point of undue hardship. So if you have tried everything that you can to the point that you can't financially afford to accommodate any further, you have that impact, that massive impact on morale, or some of those items that we did list in the undue hardship portion of it, you have to show that you've tried your best to accommodate up to that point, and then at that point you make those decisions. So is a termination an option if reasonable accommodations cannot be made? And the answer is yes. At the point we are trying to make a decision saying we've done everything we can, it's unduly hard, it is connected to somebody's job position. If it can't be accommodated, you can move towards termination. That being said, it is essential that the way that you terminate that employee and the method that you use is proper and you follow the right steps. A lot of times it can be deemed to be unduly harsh, or it can embarrass somebody. So you want to make sure that when you do, if you do need to implement the termination, that it be dealt with in a way that is really not going to unduly impact somebody's dignity and self-worth. So what are the consequences, though, if you fail to accommodate? So you haven't terminated the employment, but you simply can't do it any further. You may end up having an employee quit, which we'll go through, or they may just continue to have some complaints that they're being forced to work in violation of their human rights, which then would result in a human rights complaint, and that complaint would be initiated by the employee. The next would be a civil action. So this is moving into court. Court is what you would typically think of a court situation, which is different than the tribunal under the human rights legislation. And that would be constructive dismissal. So that would be a case if somebody was to quit based on their perceived violations of human rights, or that the workplace itself was no longer tenable for them to keep working. Wrongful dismissal would be in the court setting as well, and those are the situations where you have terminated somebody's employment. And then there could also be the employment standards complaint. So those usually arise in situations such as you didn't allow for a leave that was protected under employment standards legislation. You didn't allow a certain amount of time off for maternity leave, those types of situations, or in a wrongful dismissal, there are some requirements for notice and pay in lieu of notice. So the human rights complaint. An employee will have 1 year from the date of the alleged violation to end up filing a human rights complaint. And these tribunals are not like the typical court setting. They have more freedom to be a little bit more creative in the solutions. And so one of the cases that Kristen listed today is actually a reinstatement and bringing somebody back into work and allowing them to resume their employment. So they can do a wide variety of things, like ordering them to never do that again, or not do that. So that could be a hiring practice. So for example, if you do have an advertisement that they believe is discriminatory, they can say you must remove references to this from your advertisement. Reinstatement, as we've stated, repayment of lost wages. So they take a look at how much money this person would have likely made if you hadn't terminated their employment or believably forced them to quit. And then also general damages. So this is when we're looking at that suffering, injury to dignity, and aspects that are protected on that side. So the constructive dismissal, like I said, goes into the court setting. So the limitations period, that means they have to make a claim within 2 years from the date that they believe that they were constructively dismissed. So that what that means is that the employer's actions force them to want to leave their employment. So if they say, I can't do this anymore, I believe that I'm being discriminated against, nobody's assisting me, you haven't accommodated, I'm putting in my resignation. That doesn't mean that you're off the hook because they're now gone. That could mean that you have a constructive dismissal case against you. And it doesn't occur as a termination, but the courts treat it the same. And they look at that pay in lieu or what notice you would have to give and some additional damages as if you had terminated their employment if it is determined that it was a constructive dismissal. The wrongful dismissal, again, within 2 years, and this is when there's an actual termination. So not a resignation like constructive dismissal, this is an actual termination. And again, you would be liable for that notice in lieu, that pay in lieu, and some potential for damages based on even the mode of which you do that termination. So what are some key takeaways from this side? Take accommodation requests seriously and engage meaningfully in the process. Try not to be dismissive, even if it does not fall within what your typical understanding would be of, like Kristen said, religion or a physical disability or even a mental disability, what that accommodation would look like. Try to keep an open mind. Take a look at the reasonable context. And although it may cause some disruption, make sure that it's a case by case and it's assessed within the context of what that employee specifically needs and what your company specifically needs. And the accommodation measures must be implemented unless they'll cause that undue hardship or violate that occupational requirement. So it is a positive obligation to accommodate. It's not a choice, it is an obligation. And then those restrictions or to the exceptions do apply. And a failure to accommodate when required obviously can result in some financial liability, but not only financial liability, it can attract some additional potential press or things of that nature. If the courts do find that it is quite egregious, it could end up having a really terrible impact on your business in the long term. So a short-term pain accommodation or reasonable accommodation is usually a lot better in the long run than the financial liability or the morale and public perception issues that could arise in the event that you have failed and have discriminated against somebody. Great. So thank you very much to everyone for attending. We appreciate everyone's time. I know that lunch hour is a very treasured time of day, so we appreciate everyone coming out. I don't see any questions in the Q&A session, but obviously we're always open to follow-up questions, or if there's any issues that you do have or questions that you do have, we are always open to having some follow-up discussions with you. All right, so we have provided our contact information to reach out to us directly, myself and both Kristen. And so if you do have any questions or concerns, don't hesitate to reach out. And as always, as you'll always hear from lawyers, is if you're ever unsure, it is always the safest option to contact a lawyer, get a second opinion, because the short-term financial pain of having to engage someone is obviously better than the long-term financial liability.
Great. Well, I still don't see any questions, Randy. But I did just want to mention that we will be sending out after the presentation today, later this afternoon, we'll be sending out a recording and a copy of the slides to everybody. There's also a link in that email to us to a survey, and we're asking, it's just 5 really quick questions. We're hoping you can give us some ideas for topics you'd like to see us present on in the future, and then give us your feedback so that we can hopefully make this even better next time for everybody. So thank you again. Thanks, Randy, and thanks everybody for joining us.
Thank you, everyone.